Hi, welcome to Legally Speaking. I'm your host, Sophia Haynes. Legally Speaking is a public service of You and the Law, a nonprofit whose mission is to provide legal information and resources to empower you in your legal affairs. While we provide legal information, it's in no way intended to be legal advice, so if you have an issue, we suggest that you, and highly advise that you retain the services of a licensed attorney. We're in the midst of our criminal justice series. We call it Criminal Justice 101. And today we're going to talk about how everything gets started, and basically the prosecution portion of the criminal justice system. And we have two great guests here to talk to us about that today. Our first guest is Assistant District Attorney Darius Patillo. He is a graduate of the University of Georgia. He received his educational degree, and I guess they call you a double dog because you got your law degree from the University of Georgia as well.
That's right.
You've been with the DeKalb District Attorney's Office for 9 years. You're also a criminal justice instructor with the DeKalb Technical College, and he's a graduate of Leadership DeKalb, a 2010 graduate of Leadership DeKalb. We also have Lieutenant Tina Daniel, who's been in law enforcement for over 17 years, with 15 of those years being spent with the Clayton County Sheriff's Office and the Clayton County Police Department. She started her career with the City of Atlanta Police Department in 1988. In 1996, she continued her career with the Clayton County Sheriff's Office and worked and or supervised in just about every division in the Sheriff's Office. She's a post-certified senior instructor, a certified laser instructor. She was with the GBI Security Integrity, and she's an instructor with them. She's also a domestic violence and elder abuse awareness instructor. She currently serves as the lead public information officer with the Clayton County Police Department. Miss Daniel has been married to Angelo Daniel and is the mother of 6 children. We welcome you, Lieutenant Daniel, to the show.
Thank you for having me.
As I told our audience, we're in the middle of our criminal justice series. We call it Criminal Justice 101, and we're going to talk about the whole prosecution portion of it so that people can understand exactly what happens in prosecution. So I'll start with you, Lieutenant Daniel. Can you tell us what exactly is the role of the police department?
Well, of course, we are the first responders. When you dial 911, the police department is the agency that's going to respond when you're either the victim of a crime or you've witnessed a crime. So it's very important that when people do witness a crime or they are a victim, they dial 911 and they give us specific information to make sure we can get to the location and possibly get to the person very quickly to make an arrest.
Okay, but I just want him to leave.
Well,
and I called the police just for that. I just wanted him or her just to leave. I'm not with all that. Is that part of your role?
And it is. And usually when we come to domestic violence situations, family violence situations, it's a very volatile situation, and the officer has to determine basically who's the primary aggressor, who is the one that basically is trying to cause harm to the other individual. Could be the male, could be the female. Once that is determined, the primary aggressor is usually one that is either asked to leave the home, and we assist the victim, if you will. That can determine, or shall I say, result in an arrest, or it can result in simply the person being asked to leave the home until a hearing comes about.
Okay, but necessarily, I didn't want him arrested, or I didn't want her arrested. I just told him to get out, and he didn't want to get out. So why would the police come and arrest somebody, even though I do have a black eye? I just didn't want.
Well, here's the thing. If a crime has been committed, it's not up to our department, our officers, to determine if the person's innocent or guilty. Once we determine that there's probable cause and there's a probability that a crime has been committed, then it is our job to make sure that we start the wheel of prosecution. And unfortunately, we have to protect that victim. And many times it does mean arresting the husband, the father, the wife, or the family member.
So it's important, though, a part of your role is to determine if a crime has been committed.
Exactly.
In the midst of you wanting whatever your result you wanted.
Right. And of course, your black eye is going to be one of those clues that we would use in reference to that. Right.
Okay, so you mentioned the term probable cause. What exactly is that?
Well, again, enough evidence to prove that something possibly did happen, i.e. a black eye, scratches, furniture overturned, something showing that maybe a scuffle did take place or some sort of act of physical violence did in fact take place. And again, our job is to protect the victim. The victim doesn't always want to prosecute or again want him to go to jail, but unfortunately it's not like it used to be back in the day. It's not up to that person. If a crime has been committed, then it will be prosecuted.
Okay, so Darius, how is that different from what we hear about beyond reasonable doubt, or somebody that said, well, beyond a shadow of a doubt? Does beyond a shadow of a doubt even exist?
The actual standard at trial is proof beyond a reasonable doubt. A lot of people go around and say things like proof beyond a shadow of a doubt because that's what they hear on television and in the movies, but in actuality, the actual standard at a criminal trial is proof beyond a reasonable doubt. When you say shadow of a doubt, that suggests that you have to prove a case beyond all doubt. When actually the doubt has to be something to which you can attach a reason, such as someone else may have done the criminal act, or I couldn't have done the act because I was somewhere else at the time the crime occurred, which means I had an alibi. So the standard is actually proof beyond a reasonable doubt at trial, which is a much higher standard than the probable cause standard that
the police are dealing with.
That's correct.
Right.
When the police make an arrest at a crime scene, they're looking at it from a probable cause standard, which is a fairly low standard. They're just trying to determine whether or not, more probable than not, that this particular suspect committed the crime alleged. And Lieutenant went through a good explanation as to what type of evidence they may look to find. But once you go to a criminal trial, that standard is elevated. It's a much higher standard, and that's the proof beyond a reasonable doubt standard. So what happens is sometimes the state, the prosecution, like myself, I work at the DA's office, our job is to prove to a jury that this particular suspect, this particular defendant committed this crime beyond a reasonable doubt. Not just that more probable than not he or she committed the crime, but that beyond a reasonable doubt he or she committed the crime.
So can I, and we'll talk about the whole trial process in a minute, but since we're there, if I'm on a jury, can I have a doubt and the prosecution has still met its burden?
Sure. For example, let's say someone says that the crime happened at 3:00 p.m. And the evidence comes out. Some people may say it was 3:30. Some people say it was at 4:00. And you as a juror, you may say, well, I'm not really sure what time the crime happened, or I'm not sure if it was 3:00, 3:30, or 4:00. Yeah, that's a doubt about something, about a particular fact that came out at trial. However, that's not a substantial fact in the case. And just because you have that type of doubt does not mean that that person is innocent. Because to suggest that that was the standard would mean you have to prove every single fact, and that's just simply not the case. What the juror has to determine is whether or not they believe that this person actually committed the crime beyond a reasonable doubt. Not little things like, was it 3:30, 3:45, but did this person actually commit the crime, such as a murder or a rape or an armed robbery?
Okay. So let's just go back and just start to talk about the process. Now, Lieutenant Daniels, you go out and you see there's probable cause for that a crime of some sort has been committed. What do you do from that point? What's your next step in the process?
Well, when you're dealing with family violence, for instance, if it is one of those situations where we're unable to determine if both of you, for instance, have scars, marks on you, then we can't determine who the primary aggressor is. Then there have been times where both of you may have to be charged. We will actually either remove someone from the house, which is what we usually will try to do. If I simply ask you, okay, will you leave the house for the weekend until the temporary protective order goes into play? And you would put the facts or the information that we would have, you would go before a judge, and the judge would make the determination as to whether or not there's really a danger, or if the victim, there's possibly a future of additional violence or harm that could be done to that victim.
Okay, so you go before a judge and they determine if they're going to issue a warrant to go back over what you just did.
Right. Well, they would be charged with possibly, could be assault, could be battery, just depending. If we're not sure on that, it can range from being charged with, like I said, assault or something, from basically, okay, you two need to be separated. I would encourage the victim to file a temporary protective order, which basically is going to make sure that the primary aggressor stays away from that victim by telephone, by email, through third-party contact. Completely, absolutely stay away from that person for a directed period of time.
So I can get that at that level after you've made the initial arrest.
Right, or even if an arrest was not made, you can still file that for that temporary protective order. And the victim, that is to protect the victim.
Okay, so we're in the court process, Darius, and a warrant's been issued from the incident that Lieutenant Daniels just went out on. At that first court level, what's happening at that point in prosecution?
Well, usually there's an initial appearance where the person goes before a judge to hear what the charges are that the police have charged them with.
Is there a certain time frame for that?
Yeah, usually it's going to be within 24 to 48 hours of the arrest itself. At that time, depending on the crime, a bond or bail may be addressed. At that time, they'll hear the unofficial charges that have been charged by the police. Sometime after that, there may be a preliminary hearing, which is...
and what is a preliminary hearing? And I guess my first question is that the same whether this 24, 40 hours, whether a juvenile has been arrested or an adult has been arrested? Is there any difference at all?
Well, with the juvenile, you have to have a detentional hearing within 72 hours of the actual arrest. Statutorily.
So there are some differences.
There are some nuanced differences, but that's the latest. Usually we try to have those hearings, particularly for juveniles, much as early as possible. Sometimes it may not be possible if a child gets arrested on a weekend. For example, if it's Saturday, it may have to wait until Monday because the following day is Sunday and court's not open. But a preliminary hearing is where the court has to determine whether or not the police did in fact have probable cause, and the difference between that type of hearing is that the state, the DA's office, or the police will have an opportunity to call witnesses to testify in front of a judge to list out what the probable cause evidence was against that person. And from that point, the state will present the case to a grand jury, and the grand jury is basically a group of citizens who actually come into a room, and they are chosen randomly, and they determine whether or not probable cause was present for the police to make that arrest.
So where does that list for the grand jury come from? Because I can see a point where the private citizen could get involved at some point.
Well, the grand jurors are selected just like any other trial jury, basically through court services and the court administrator's office. They facilitate that process.
Through your registered voters.
Yeah, your registered voters.
Registered voters.
You have to be registered voters.
That's right. A lot of people are familiar with a trial jury because that's what we see on television.
Yeah.
And we hear about grand juries, but a lot of people don't know how you get on a grand jury or where they meet and that type of thing. The grand jurors actually meet and vote in secret. So the grand jury proceedings are not open for public observation.
Okay. So we've got to this point, we've had the preliminary hearing, and we're at that same low probable cause standard at this point.
That's right.
So judge hears it and they say, okay, well, I agree there was probable cause to arrest. So what happens next?
Okay, at that point, as I mentioned, when you go to a grand jury, the state will bring witnesses, usually a police officer or a victim, to testify to a grand jury to tell them this is the evidence that we have that John Doe committed this particular criminal act. At that time, everyone will leave the room, including the person representing the state. The witnesses will leave the room, and the only people left in the room are the grand jurors and their foreperson, and they will vote amongst themselves and decide whether or not there's sufficient probable cause for the case to go forward. If they say, yes, there is sufficient probable cause based on the testimony we just listened to, then they will issue what we call a true bill of the indictment. If they disagree or they decide that there isn't enough probable cause on the evidence, they will issue what they call a no bill, and then the case cannot go forward.
So is that the same whether I'm charged as a misdemeanor account or a felony account, or is there a difference?
There is a difference. Misdemeanors don't have to go before a grand jury, but felonies do. Most felonies do. Not all of them. Statutorily, the legislature allows for some cases to go forward by accusation, but that's usually non-violent type of crimes like your forgeries and certain thefts and things like that, non-violent cases. But your murders, rapes, armed robberies, and the more violent crimes, the more serious felonies, all have to go before a grand jury.
So how much discretion does the prosecutor have? And whether it's a misdemeanor or a felony, is whether this case goes forward or not?
Well, the prosecution has a lot of discretion in terms of what the actual official charges will be.
So just because Lieutenant Daniels arrested somebody doesn't necessarily mean these people will face charges in court. Is that what you're saying?
Right. They may not face charges in court at all, or they may face a different set of charges depending on the analysis of the case. What the DA's office has to do is look at the case that's been delivered to us by the police department, determine whether or not there's enough evidence to charge anything, and if so, what should actually be charged. Sometimes the state, the DA's office may decide to charge more than what the police have already charged. They may decide to charge less. And sometimes the charges may be completely different. Or like you pointed out, there may be no charges that are taken forward based on further investigation in the case, because our office is responsible for doing additional investigation after we receive the case from the police department.
And that sounds like a lot of discretion that's in the hands of that person. So it's important to know who's sitting in that office, sounds like.
That's absolutely true. That's absolutely true.
And it's very important, of course, on the police department end. That's why it's very important we have our facts together. A lot of it is based on our reports and what we give, the witness statements, and basically how we unfold the story. So if we forget to dot an I or cross a T, it can really destroy a case. So it's very important that we make sure we follow thoroughly all of the information from that particular case.
And sometimes it's not the police's fault when a case things happen in the case that change. Sometimes we find out information that the police did not have. Sometimes we'll find out there are additional witnesses. We'll find out facts and circumstances about the case that were unknown to everybody until we dug a little deeper into the case. And once we do that, because we have to look at it through a different lens, I have to look at it to see whether or not I can prove it at trial versus they're looking at it to see if there's enough evidence to make an arrest. Right.
Very good distinction. Okay, we're going to take a break here. This is excellent information. And when we come back, we're going to talk about that whole trial process and what happens and how the public can get involved in that. Okay. We'll be back in just a second. You are tuned into Legally Speaking, a public service of You and the Law. You and the Law is a nonprofit whose mission is to provide legal information and legal resources to empower you in your legal affairs. If you would like to have a question answered or a topic featured on Legally Speaking, feel free to contact us online at www.youandthelawtoday.org. You can also sign up there on our website for our mailing list, as well as follow us on Facebook and Twitter. Remember, with every right comes responsibilities, so know your rights and accept your responsibility. Welcome back. We're in the middle of our Criminal Justice 101 series, and we're handling the prosecution side today with Assistant District Attorney Darius Patillo and Lieutenant Tina Daniels. Okay, before we left, we talked about the whole arrest, and we're getting the warrant, magistrate, and all of that. So now we've been indicted, and now we're coming up to the point where we're actually getting to the trial portion of it. What is the first step after someone's been indicted? When will be the next time that person will see a courtroom, Mr. Patillo?
After a person is indicted, then that person has to have what we call an arraignment hearing.
And what is that? And
that's basically a hearing in front of a judge where the criminal defendant is allowed to hear in open court the charges against that particular person, and those will be the official charges that are brought by the district attorney. It may be those charges may be different from what the police initially charged them with, but they'll get a chance to hear those charges in open court if they choose to have it. They can always waive that. You don't have to have that, but they have that opportunity and that right. They'll also hear about their legal rights in terms of their right to remain silent, their right to have an attorney, their right to seek their own private attorney or have one appointed to them if they cannot afford one. And they'll also get a chance to enter a plea of guilty or not guilty.
So it sounds like a very important proceeding that they don't want to miss.
Absolutely. In fact, if you miss that proceeding, then there's a chance that there will be a bench warrant issued for that person's arrest if they're not already in custody.
Also, because sometimes there's a delay between the arrest and your actual arraignment time.
That's
so
right.
How, if I move, would I coordinate with the police department or with the prosecutor's office to let them know that I've moved and anything that you want to know from me?
Right.
This is where you can find me.
That's a great question,
Yes.
Sophia, because that happens quite a bit. People will get arrested and get a bond and get released from jail with a court date for sometime in the future. They'll get a notice for that court date, but what'll happen is, or notice is supposed to be forthcoming. What'll happen is they'll move between that time frame, and the district attorney's office and the courts, they only have the address, the last address that defendant gave them when he or she was arrested or released from custody. And that's the address that the court system relies on. And if they fail to get a notice because they may because they moved, there may be a bench warrant issued. The step that can be taken for anyone who has a court date in the future and you are relocating and moving, a good step would be to call the district attorney's office or the prosecuting agency to let them know that you have moved and have a new address, and change your address within their systems to make sure that you'll get all the court notices, because you don't want to take a chance on being arrested for a second time and having your life disrupted.
So it's not responsibility is on them.
Right.
Absolutely.
And to follow up on that, of course, many times people get arrested. They may get pulled over for a speeding ticket or at a roadblock and find out, what do you mean I'm wanted? What do you mean there's a warrant for my arrest? Well, again, they moved. They didn't realize when the court date was, did not show up, and people don't realize, but that bench warrant is issued immediately. When your name is called and you do not show up, that judge will sign that bench warrant immediately. And that following day, you're wanted.
And people need to be more proactive about keeping up with what's going on with their cases.
Exactly.
Just because you haven't heard anything for some time, cases move at a different rate depending on the jurisdiction you're in. Just because you haven't heard anything, don't assume or presume that the case has been dismissed.
That's an excellent point. I think it happens a lot.
You hear that all the time.
Exactly.
I didn't hear anything. I thought the case was dismissed. Next thing you know, they're taking their kids to school and get pulled over for a traffic citation, and there's a bench warrant out for their arrest. So if you haven't heard anything about a case and you have been charged and you need to know what's going on with it, just pick up the phone and make a phone call down to the DA's office or the solicitor's office, whoever's prosecuting the case, to get an update, a status update with the case.
Absolutely. Highly important.
And unlike on TV, this crime usually doesn't go through the entire process in 3 commercials. In 3 commercials. And it can stretch out to several months, and it is not uncommon. People don't realize how long the actual juries, that system can take to go through the entire process. And so after several months, again, people have that false sense of okay, well,
No
I must have
news
cleared.
is good
Right,
news.
no news is good news.
Well, if
and
it's
that
not
is
in
not the
writing,
case.
people, it's not dismissed. Okay, now we're at the trial process, and Lieutenant Dance has done her best to build this case, and Ms. Patillo's trying to build his case. How important are the people that actually saw what happened? How important are they to this process? And how important is it for them to follow this process all the way through?
Very important, because many times without the witnesses, there is no case. And I know many people, they don't want to get involved. I saw it, I called the police, I did my job. Well, unfortunately, that is not the end of it.
That's the beginning.
That is the beginning. And if you were a victim, I would hope you would not want someone else to become a victim of the same crime. And you could, again, help stop this cycle. So it's very important that you have to go to court. Yes, it's a minor inconvenience, but it could stop someone else from having to go through what you went through.
Exactly. And what about in the trial process for you?
Well, the same thing. Witnesses are critical. I believe we have a moral and civic duty to serve as witnesses when we actually have information about a case. And I think it's important to highlight that you may be a witness even if you didn't see the actual crime. A lot of people think I'm not a witness because I didn't actually see the stabbing, I didn't actually see the shooting, I didn't see the car accident. Well, that's a type of witness, that's an eyewitness, but you may be a witness to the case because you have other information about the case itself or about the individuals involved in the case. You may know something about this particular person. One of the suspects may have told you something even though you didn't see the crime. You may have gotten information from the suspect or a third person. And I think people need to understand that just because you didn't actually see or hear a criminal act does not necessarily mean that you are not a witness and will not be called as a witness. Because I hear that a lot in the trial process. Well, I didn't see anything. I don't know why my name is listed on the witness list. Well, your name is listed on the witness list because this person was arrested at your house, or your name is on the witness list because we know that you were with him prior to the act, or something like that, or you're the person who actually called 911.
Right.
Even though you didn't see what happened, you're the person who called the police.
So you have something to this story that can help bring it out fully.
Right.
And it's all about balancing the rights of everybody involved. The state has a right and the other person has a right in this process. So let's go along the whole line of witnesses. We hear a whole lot, and I can remember as a prosecutor listening at the calls. Well, if you don't show up, the case is going to go away. Is that necessarily true, Darius?
Not necessarily. If people don't show up, that does not mean the case will automatically be dismissed. The state has the discretion as to whether or not the case will ultimately go to trial, and that lies with the state. And we can compel victims to testify by issuing a subpoena, and that's something people need to know. If you are issued a subpoena to be in court and you fail to show up, or you'll try to affirmatively avoid service, you may get a warrant issued for your arrest. We call that a material witness warrant, and the state can ask the judge to issue that if you fail to show up on the subpoena, or if we can show that you are trying to evade being served with the subpoena.
And that's a very critical point, because a lot of individuals think, well, if I call you, tell I want to drop the charges, that should be it. So can a victim drop the charges?
No.
It doesn't work that way.
It doesn't work that way. It is one factor of many factors that the state look at. The state looks at to determine whether or not a case will be dismissed. It is one factor, and it's not necessarily always the biggest factor. It just depends. We look at each case on a case-by-case basis to make our assessment.
So it sounds like that the victim didn't bring the charge in the beginning. The state brought the charge.
Right. The victim started the process by calling 911, and that's something people need to keep in mind, that when you call the police and get the police involved, it's not like a light switch where you can just turn it on and turn it off. Once you start that process, you can't necessarily control it. A lot of the discretion and decision making will be left up to the law enforcement officials who will be involved in the case. And
I think it's important to note also that if you called the police in the beginning, apparently something was wrong, and you reached out for help. And just because things may appear to be smoother now doesn't necessarily mean that you don't have an issue that you need to resolve. And I think sometimes people think, well, we made up, or he returned my items, or she paid for the damage to my car, and there's not an issue anymore, but we still need to resolve the issue that brought you before the court.
That can also still serve as documentation as well, because that initial call will also serve as a type of documentation where, okay, now we've got a pattern, now we've got a history. So it's still very good to call.
Absolutely. Okay, we're toward the end of this show. Is there anything that you'd want the public to know about the role of the police, the role of the prosecutor in this process? I guess let me ask this question. We talked about witnesses. How important is jury service, Darius, to this whole scheme?
Jury service is part of your civic duty as an American citizen. I mean, it's just like voting, and just like a lot of other things that we are expected to do. It's very important for people to be involved in the process, to vote in our elections for district attorney, for judges, and just like we vote for president, because all politics is local. It's very important to know who's at the helm of your criminal justice system. And that's what I would want to leave your viewers with, is that they need to be a part of the process, and keep in mind that the DA's office's job is to protect the community. We're here to help. We're here to make sure that people are not harmed. We don't like crime in our communities. We want to make sure that our kids are safe, that our kids are educated. And a lot of people think that all we do is try and lock people up and keep people in jail, but that's only a small part of what we do in terms of trying to protect the community. Sure, some people need to be incarcerated, but we also try to make an effort to prevent crime from happening at all by intervening in the lives of young people, speaking at schools, having programs and services that are designed to keep people out of the process, because that's less expensive, as well as provides a valuable service to the community.
So the police and the prosecutor are your friend, is that?
Yes,
that's
very
right.
much. We're here to protect and serve the community, and help empower people to realize that this is their community, and they are the eyes and ears to help the police department, and it's really a partnership.
And actually, they determine what their community is going to look like.
Exactly.
By how they participate in that. Well, we are all out of time, if you can believe that. I want to thank you both so much for coming on, because I believe that you brought some substantial information and cleared up some myths out there about what happens with the police department, what happens in the prosecutors, what you can and cannot do, and actually gave some information to broaden their knowledge base as to the whole criminal justice system. So I want to thank you so much, both of you, for coming.
No problem. Thanks for having us.
Well, there you have it, folks. That's Criminal Justice 101. We talked about on the prosecution side with the police as well as the prosecutors. Remember that Legally Speaking occurs every Sunday at 6 p.m. on www.unithelawtoday.org. And remember, until next time, with every right comes responsibilities. So know your rights, accept your responsibilities. We'll see you next week.